Hello, and welcome to OrphanJerks, where we try to educate the artist about his or her rights in the expanding legal landscape as it concerns creation, distribution, and ownership of intellectual property in general, through artwork specifically. My name is Serge Milstein, and I'll be your artist, sampler, business owner, and host. The issue at hand is the proposed legislature referred to as Orphan Works. This does not deal with abandoned children or some kind of slave labor law. The orphan referred to here is a work of art, whether drawn, musical, or otherwise expressed, that has no known owner or parent. This happens because commercial viability has expired, or because the authors don't mind being sampled or referenced. Finding a parent using visual registries can prove exhausting and costly, and once a parent is found, only reasonable compensation or a licensing fee is necessary. But what if you don't register? Doesn't the owner own his art? The new legislation greatly limits responsibility and consequences for the infringer. In lieu of any strict penalty, reprisals against unfair use will be limited, and this facilitates the intentional orphaning of a work. If the Mona Lisa hangs on my wall, I'm obviously using a property that does not belong to me. But what if I have a poster of the Mona Lisa, or a coffee mug that displays her image sipping a martini poolside at a resort? Since art is simply a unique encoding of information, this information may take some form which can be interpreted as property of its author. In fact, the word author may refer to a number of occupations or crafts. They are creators, authors of the arts. We assume that as the creator of the work, we are automatically the owner as well. In fact, it may be necessary to look at authorship and ownership as individual concepts. Consider that inferred ownership was established for the United States in 1976. That's less than 40 years ago. It may seem a long time ago in terms of computers and internet, but in terms of law and world history, 1976 is fairly recent stuff. Before that, artists were more accustomed to selling their property outright rather than copyright. This is because copyright has a winding and sordid history of its own, which predates the US Constitution. Traditionally, exact copies were extremely difficult to make. In the 1400s, the printing press changed that forever. Bootlegging became commonplace, and distributors lost a lot of investment money. All these copies acted as an index to the value of an original, but now the original they signify could actually be intangible property. Information establishes itself as a durable commodity, which over the coming years could be presented through new and transient formats. Ever since the Industrial Revolution, the law has been chasing technology. England created a monopoly for the Stationers' Company with the Licensing Act of 1662. This was a collection of printers that were given the charge of keeping a register into which all printed books had to be entered. By 1710, the Statute of Anne, the first copyright statute in Britain, was put into effect. Although it may not have defined authors' rights, it did recognize the legality of authorship, and it addressed the concept of public domain. The United States Patent and Trademark System, like most U.S. law, is based on the British system. The U.S. Constitution famously addresses the virtues of copyright, and the United States policy on copyright was almost word for word lifted from the Statute of Anne. United States copyright was originally an opt-in system, meaning you had to pay money and actively acquire protection for original works. In 1976, copyright protection became automatic, but did not fully realize how computers would impact civilization, and ended any sort of mandatory registration. Artists and owners have been told for decades now that they need not do anything to protect their copyright. Artists need to take more of an interest in the law surrounding their creations. Due to the advent of the instant perfect copy, no labor was expended in the creation of a downloaded file, and no physical product was removed from a store unpaid for. As much as record labels would have you believe otherwise, file sharing is not the same thing as shoplifting. Today, publishing is the artist's promotional tool, and licensing is the way to break into that big media money. Indeed, a fairly new business model. It can signify the difference between durable property and transient products. So is the orphan ready for a new master? Or is the orphan a new breed of art and information which we all share as a community? Only time will tell. OrphanJerks urges you to remain alert to developing technologies and the legalities of authorship in this new age of instant reference. Many issues are on the horizon, and I look forward to examining them more with you on OrphanJerks.